I will discuss on the first issue, which is whether the action of the local authorities infringe the right of Cynthia and the public under this constitutional law and human rights perspective. So in this first issue, there are two sub-issues, which are, the first one is whether the action of the local authorities demolish any illegal structure built without the permission infringe the right to own property. Secondly, whether the action of the local authorities to prosecute individuals who set up a stall without a license infringe the right to life and personal liberty. Alright, for the first sub-issue, we refer to Article 13 of the Federal Constitution, where it mentions the right of property of person of the country. So this provision ensures the property is being protected. Also, we refer Article 13 Clause 1, where it mentions that no one can deprive the property of another person. So the property in this provision includes all forms of property, either intangible, tangible, movable or immovable. Also, the phrase safe in accordance with law in this provision, it defines that the property cannot be deprived unless the law said otherwise. This is subjected to Article 13 Clause 2, where the property of the person can be deprived if the law allow. Next, we refer to the case of Ong Ah Chuan MPP, where it mentions that the Parliament has the power to enact any law to destroy or deprive or acquire or regulate private property within its jurisdiction, where the only restriction is that the compulsory administration must provide the adequate compensation as per Article 13 Clause 2. Also, based on the human right perspective, we quoted the Article 17 of the Universal Declaration of Human Rights, which is UDHR, where it states that everyone has the right to own property and no one can deprive the right. Other than that, we also refer to Article 5 Clause 1 of the Federal Constitution, which mentioned the right to life and the personal liberty of persons. So here we emphasize on the personal liberty, where it includes the right to livelihood, the right to access healthcare, and the right to earn enough money with dignity, as well as the right of person's reputation. So, however, there also a phrase safe in accordance with law in the provision, which it defines that the authority has the legal power to deprive the person's life and also personal liberty. So here we refer to the case of Ketua Pengarah Jabatan Alam Sekitar and Kajing Tubik, where in this case, the state government of Sarawak had used the land for its development project. So the project will take away the means of living and means of earning of the persons who are living in the area. So the court held that although the government is taking away the livelihood of the people living in that area, the action by them is legally valid because it complies with the existing law. So therefore, the state government of Sarawak didn't violate their right as they acted in accordance with the law. Applying all principles in our case, the local authorities acted on their power and jurisdiction, where they didn't unlawfully deprive the property of another and that didn't infringe the public's right under Article 13 of the Federal Constitution as well as Article 17 of UDHR. Also, the local authorities are allowed under the law to deprive the property, and the law must provide adequate compensation as mentioned in Article 13 Clause 2 of the Federal Constitution. Also, we quoted the case of Ong Ah Chuan MPP, where the State Legislative Assembly can enact any law to deprive or acquire or regulate private property within its jurisdiction. On top of that, we also refer to the Article 5 Clause 1 of the Federal Constitution, which in our case, the local authorities did infringe on the right of the persons to livelihood as they demolished the building. However, referring to the phrase safe in accordance with law, the local authorities had acted with valid legal power to deprive the person's property. So here we refer to the case of Ketua Pengarah Jabatan Alam Sekitar and Kajing Tubik, where in this case, although the local authorities are taking away the livelihood of the people living in the area, the action by them is legally valid because it complies with the existing law. Thus, the local authorities didn't violate the public's right because they acted in accordance with law. Moving on to the second sub-issue, where in this case, here we also refer to the Article 5 Clause 1 of the Federal Constitution, where we emphasize on the personal liberty, on the right to earn enough money with dignity. So here we refer to the case of Kerajaan Negeri Johor and Adung bin Kuau, where in this case, the defendant agreed with the government of Singapore to build a dam in Ligu Valley, which this project interfered with the living and earning of the persons who are living in the area. So basically, in this case, the court held that the plaintiff, who is the people living in the area, should be compensated for losing their livelihood. Also, the right will also being upheld as the land was occupied by them, which the acquisition of the land by the government must be in accordance with the law, even though they know that the people living there is not registered under the land, not registered under their name. In applying our principle in our case, the action of the local authorities to prosecute individuals who set up store without a license had deprived their personality under Article 5 Clause 1 of the Federal Constitution. However, we quoted the case of Kerajaan Negeri Johor and Adung bin Kuau, where in applying, the local authority has the power to prosecute individuals who set up the store without a license as they had acted in accordance with the law, as they are a provision that allows them to regulate license and prosecute individuals who lack of license for business. So the provision is provided in the Local Government Act 1976. Also, based on the human right perspective, there are nothing mentioned that the local authorities torture or being inhuman towards the public. Overall, based on the first issue discussion, the action of the local authorities did not infringe the right of Cynthia and the public to own property under Article 13 of the Federal Constitution. However, the law must provide adequate compensation as per Article 13 Clause 2. Also, the right of personal liberty under Article 5 Clause 1 of the Federal Constitution also infringed by the local authority.
The second issue arising is whether Cynthia and her friends are protected by the provision in Part 2 of the Federal Constitution and human right perspective. So there are three situations that fall within such an issue. So the first one, Cynthia with fellow social activists organised a meeting with other social activists to discuss these issues fall within Article 10 Clause 1 Clause C of the Federal Constitution. So to Begin with, Article 10, Clause 1, Clause C of the Federal Constitution give every Malaysian citizen the right to form associations. These include political parties, NGOs and activist groups. However, this right is not absolute. Parliament can limit it for reasons like public safety, morality or public order as stated in Article 10, Clause 2, Clause C of the Federal Constitution. Association must also be legal, in which they need to be registered under the Societies Act 1966. If they aren't registered, they cannot function legally. The Registrar of Societies or ROS also has the power to reject or cancel registrations if the group is seen as threat to public interest. The court have confirmed both the rights to associations and limits to that right. In the case of Nordin Saleh and State Legislative Assembly Kelantan 1992, the Federal Court ruled that only Parliament, not state government, can limit this freedom. If any law contradicts the Constitution, it is invalid under Article 4, Clause 1. In another case, Datuk Muhammad Nasir and Menteri Dalam Negeri, the ROS set a reasonable requirements for a political party's registrations. The court found these rules lawful as long as they were fair and follow the law. In another case, Datuk Muhammad Nasir and Menteri Dalam Negeri, the ROS set a reasonable requirements for a political party's registrations. The court found these rules lawful as long as they were fair and follow the law. Internationally, the Universal Declarations of Human Rights (UDHR) also supports these freedoms. Article 20, Clause 1 said everyone has the right to peaceful assembly and associations, while Article 19 protects freedom of opinion and expression. Although the UDHR is not legally binding, Malaysia, as a United Nations member, is expected to follow its principle as long as they did not conflict with our constitutions. So now, in applying those principles in our current situations, she formed an informal activist group to protest social and economic issues. Even if her group is unofficial, in which they did not register under Societies Act, it still falls under the protection of Article 10, Clause 1, Clause C of the Federal Constitution as long as their activities are peaceful and legal. Unless the authorities can prove that her group is a real threat to the public order, stopping her based on registration status alone would be unjust. Cynthia also used social media to speak out against what she sees as unfair laws. This aligns with her rights under Article 19 and 20 of the UDHR. This right protects both freedom of expression and the right to campaign for change. If the government tries to silence her without real evidence of harm, it could be violating the constitutions. So long as Cynthia follow the law, any restrictions placed on her must be necessary, fair and within legal bounds. So, to conclude, Cynthia and her group are exercising their rights under Article 10, Clause 1, Clause C and also under article that applicable under UDHR. Any interference by the government must be legally justified, in which they need to prove whether the association give harm to the public interest or morality or others. Otherwise, it would breach both their constitutional and internationally recognized rights. So now we're moving on to the second situation, in which it covered under Article 10, Clause 1, Clause A of the Federal Constitution and also under Article 8 of the Federal Constitution, particularly Article 8, Clause 1 and also Article 8, Clause 2 of the Federal Constitution. So, under Article 8, Clause 1 of the Federal Constitution, every person is equal before the law and entitled to equal protections under it. This means that no one, regardless of their social status, race or background, should be treated unfairly or given special treatment under the law. Under Article 8, Clause 2, further strengthen this by specifically prohibiting discriminations based on gender, race, religion, descent, or place of birth. This applies in public employment, property dealings, and even the enforcement of law itself. So now, we're moving on to Article 10, Clause 1, Clause E, guarantees, in which this article guarantees the right to freedom of speech and expression to all citizens. This includes speaking out, posting online, organizing public talks or protests. Basically, any form of peaceful expressions. However, this right is not absolute. Under Article 10, Clause 2, Clause A of the Federal Constitution, Parliament can impose restrictions to protect national security, public order, morality and more. This is where laws like Sedition Act 1948, Communication and Multimedia Act 1998 and Defamation Act 1957 come into play, especially if someone's speech is false, harmful or incites unrest. Look how the courts have interpreted this right. So, in the case of PP and Tengku Muhammad Iskandar, the High Court made it clear that everyone is equal before the law. Even royal doesn't justify lighter treatment. This case reinforced under Article 8, Clause 1 that justice must be same for everyone. Then, in the case of Nur Fadila and Syed Basirun, the court ruled that denying a pregnant woman a job due to her pregnancy was unconstitutional under Article 8, Clause 2. This case shows that discrimination in employment, especially based on gender, is not allowed. When it comes to speech, the case of PP and Puah Keng Tong recognized that freedom of expression includes not only spoken words but also signs, images and publications. Similarly, in Utusan Melayu and Datuk Seri Adina Yaakob, it was held that the press freedom is rooted in Article 10, Clause 1, Clause A but must still comply with reasonable legal limits under Article 10, Clause 2, Clause A. So, how this principle apply to Cynthia situations? So, Cynthia and her fellow activists are using social media to speak out against what they see as discriminations by the local authorities. They are accusing officials of racism, religious bias, and unfair treatment of street vendors and stray animals. Under Article 8 Clause 1, Cynthia is right to expect that the law be applied equally, and if some groups are being treated more harshly than others, that is a potential breach of equality. If these alleged actions by the authorities are truly based on race or religion, that could breach Article 8 Clause 2, which clearly prohibits such discriminations. Cynthia's post and plan protest also falls under freedom of expressions and protected under Article 10 Clause 1 Clause A. Whether she is using social media or organizing demonstrations, these are legitimate forms of expressions. But as I mentioned earlier, her rights can be restricted. If her speech crosses the line, if her comments are defamatory or incite public disorder, laws like the Sedition Act or defamation could be used. However, if her action remain peaceful and grounded in facts, then this restriction would be difficultly to justify. So now let's bring in the international perspective. Under Article 7 of the Universal Declaration of Human Rights, everyone is equal before the law and entitled to equal protection without discriminations. It is a direct reinforcement of Article 8 of our constitutions. So, also based on Article 19 of the UDHR, further declares that everyone has the right to freedom of opinion and expressions. This includes the right to see, receive, and impart information to any media, regardless of frontiers. Finally, Article 2 of the UDHR guarantees that this right apply to all people, regardless of their races, religion, political views, or other status. These provisions confirm that Malaysia Constitution guarantees are aligned with the international human rights framework. So, it can also be concluded that Cynthia's action by posting online and planning a protest are protected under both the domestic constitutional law and international human rights law, as long as her speech remain peaceful and fact-based. The authorities must respect her rights. Any restriction must be reasonable, legal, and proportionate, not driven by discomfort with her message. For the last situation in which they plan to do a fiery demonstration outside the office, this fall within Article 10 Clause 1 Clause B of the Federal Constitution, in which under such provision mentioned that all citizens have the right to assemble peacefully and without arms. This is a core democratic right. However, this right is not absolute. Parliament is allowed to impose restrictions under Clause 2 and 3, especially to protect national security, public order, and the general well-being of the federations. To give effect to these restrictions, Malaysia enacted the Peaceful Assembly Act 2012 or PAA. This act outlines the proper process for organizing public gathering. Most importantly, organizers must give a 5-day notice to the officer in charge of the police district. This is not about asking for permission but simply notifying the authority. The police can then impose conditions on the protest, like when it can happen, where, for how long, and how it should be conducted. Protests cannot be held within 50 meters of sensitive area like hospitals, schools, and place of worship. If organisers doesn't comply, they may face penalties under Section 20 of the PAA, including fines and arrest without warrant. Now, if a protestant's violent or threatening, it may even fall under Section 141 of the Penal Code, which criminalize unlawful assemblies involving force or coercions. Finally, from an international law perspective, Article 20 Clause 1 of the Universal Declaration of Human Rights protects the right to peaceful assembly. While the UDHR is not binding, Malaysia is expected to align its laws which its principles, meaning that any restriction must be reasonable and proportionate. There are several cases that help us understand how these rules are applied in Malaysia. In the case of Nik Ahmad and public prosecutor, the Court of Appeal struck down the 10-day notice requirement under Section 9 of the PA, saying it was unconstitutional and had no logical link to the public order. But in the case of PP and Yunus Waran, the court upheld the validity of Section 9 Clause 1 and Section 9 Clause 5, saying that the notice requirements is a procedural safeguard, not a barrier. Earlier cases like Cheah Beng Poh and PP and Morgan anak lelaki Mudiandi and PP involve Section 27 of the Old Police Act, which requires police permits. These cases supported strong police control, but their relevance has reduced since the PAA came into force. Also in Nik Nur Hafizi and PP, the court upheld Section 27's constitutionality, but again, this case has less weight now because the newer PAA. Now, let's apply these rules to Cynthia's situations. Cynthia is a university student who's deeply involved with social causes. She and others activists plan to hold a protest outside a public authority's office. They want to raise awareness about the treatment of stray animals, the removal of unlicensed stalls, and the demolitions of unauthorized structures. According to Article 10, Clause 1, Clause B, Cynthia clearly has a constitutional right to organize and participate in a peaceful assembly. Her intention is non-violent, and she is not carrying any weapon, so the basic legal rights exist. However, under the PA, Cynthia has certain duties. She needs to notify the police at least 5 days before the protest. If she fails to do this, she may be penalized under Section 20 of the PAA. Even though the protest is automatically illegal, failure to give notice opens her up to enforcement actions. Next, she must follow any restrictions set by the police. For example, the location is too close to a school or mosque, say within 50 meters, then it is prohibited area, and she will need to relocate. If she ignores these conditions, she risks being charged under the PAA or even under Section 141 of the Penal Code if the protest turn disorderly. So while Cynthia is exercising her rights, she also has responsibility to ensure that the protest remain peaceful, lawful, and in line with PAA's procedures. Importantly, under Article 20 Clause 1 of the UDHR, Cynthia's right to peaceful assembly is supported by international human rights standards. This strengthens her moral and legal positions, and any restriction imposed on her should be reasonable, proportionate, and justified, in which it in line with Malaysia's commitment as a united member. So to conclude, Cynthia's plan to protest is protected by both of the federal constitutions under Article 10 Clause 1 Clause B of the federal constitutions, and by international human rights principles under Article 20 Clause 1 of the UDHR. But these rights come with conditions. Cynthia must comply with PAA, Peaceful Assembly Act 2012, give proper notice, follow police guidelines, and make sure her protest stays peaceful and lawful. As long as she does all of that, her actions are not only legal, but they also reflect the healthy democratic values that both nations and Malaysian Constitution and the UDHR seek to protect. That's all from us. Thank you.